Where can the government ban you from possessing firearms? Well, that's what we're looking at in this video. We're going to be taking a look at what the U.S. Constitution, as well as what the U.S. Supreme Court and courts have said in the Bruen decision as far as what constitutes a sensitive location. Keep in mind, a sensitive location means that a state, local, or federal government can ban carry in it. I'm not asking you to agree with that. I'm just saying that's what the U.S. Supreme Court has said. So guys, let's get into it. So the legal standard that we have to keep in mind, set up by the Bruen decision in the U.S. Supreme Court's landmark case announced in June of 2022, is that when applying the Second Amendment test, it is as follows. When the Second Amendment's plain text covers an individual's conduct, the Constitution presumptively protects that conduct. It is now the government's burden to justify its regulation by demonstrating that it is consistent with the nation's historical tradition. And in plain English, what this means is a little bit of a two-step test. First, does the regulated conduct fall within the text of the Second Amendment? And if so, number two, is there historical support for the conduct that's being regulated? Now, to win, the government must justify the regulations by demonstrating that the regulation is consistent with the nation's historical tradition or firearm regulation. So it doesn't have to be a direct twin. It has to be what we call an analog. In other words, are we close to each other in principle, but it doesn't have to be like a tannery in order to match something, or I don't know, take some sort of 18th century occupation or 17th century occupation. You get my point. The U.S. Supreme Court actually did put out a couple canonical definitions of, look, these are places where it's going to be lawful for the government to basically make it a gun-free zone. And again, I'm not asking you to agree with it. I'm just saying here's what it is. And the U.S. Supreme Court has said that this is undisputed and uncontroversial. There are certain government buildings. So number one, certain government buildings such as legislative assemblies or courthouses, or where the government is acting within the heartland of its authority. Number two, polling places. And number three, schools. That's it. Within the heartlands of its authority when it comes to certain government buildings, polling places, and schools. Now, Bruen further instructs courts to consider analogies to such sensitive locations when considering whether the government can meet its burden. So what are some places that the government's been trying to restrict things? Well, let's think about kind of recreation areas. We think about beaches, movie theaters, sporting events, concert venues, amusement parks. Is that the heartland of the government place? Is that government property that's at the heartland? Is that a polling place? Is that a school? Probably not. Those are probably going to be pretty easy laws to get struck down. Now, for instance, when we talk about a playground, though, a court did find a playground is kind of in the same sphere as a school. It's a place where children congregate and gather. Now, of course, you can then continue to extend that analogy to say, well, therefore, and the government has done this and they will do this. Well, look, so any place where children congregate. So now we're talking about every single store, gas stations, we're talking about movie theaters, and you can see how the U.S. Supreme Court would probably say, maybe to the playground, no to everything else. You're taking too many logical leaps here because at the end of the day, a movie theater is not a school. Different spheres, they're too far apart in the analogies. Let's talk about commerce. Again, we talked about shops, stores, restaurants, and all those sorts of things. Is that a government building? No. Is that, even if it were a government building, is that within the heartland of the government power? Is it a polling station or a school? No, no, no. Again, more interestingly, we kind of get to medical and spiritual places. Think hospitals, urgent cares, clinics, and places of worship. Are those one of those three? Probably not. And again, these are all things that, of course, the government loves to regulate because they love to regulate places where, frankly, anytime there's people. So we're going to be seeing from a sensitive locations analysis that all these places that all these state governments are putting these slapdowns on, they're probably not going to stand up to any constitutional muster here. What about government property, such as airports, libraries, parks, forests, all that kind of stuff? Well, again, libraries. No one can seriously contend, for example, that the state could impose a gun-free highway system simply because it happens to own the infrastructure. The government owning something is not the question. The question is whether or not it falls within the heartland of government authority. Is it the place where core government institutions, core government business is transacted? Look, I love libraries, but at the end of the day, I don't even think this is close. The answer is invariably going to be no. Owning the land does not automatically make it within the heartland of a core civic function. Same thing goes when it comes to parks, and there's actually been a long case lineage about this, as well as when we talk about forests and other things as well. So once more, I think we're going to see all those sorts of things fall by the wayside in all the different states that are just reflexively passing anti-Second Amendment, anti-carry. But I want to talk about a big issue that's out there, and that's kind of the public-private property inversion. But first, show your support not only for this video, but also for the Second Amendment. Click like. It tells the algorithm this is a good video and other people should see it. And it's also the best single thing you can do to help this channel grow. And of course, it also tells me, hey, this is interesting and I want to see more videos and topics like this. Also, of course, don't forget to hit subscribe to make sure you don't miss any of our future content. If you want to take it above and beyond, we also have membership options to help our project grow. There's exclusive options for those folks as well. And of course, comment below, what do you think about this? Where do you see this going in the courts? How crazy do you think all this kind of stuff is? And of course, don't forget to stick around for our quote of the day. That's going to be closing out all of our videos as we move along. Now back to the show. Okay, so this is going to be a big deal. So pro-gun, pro-freedom states generally say this. If you go into someone's home, if you go into someone's shop or something like that, private property owners can basically post and lawfully restrict the presence of firearms on that property. And those signages will have the force of law differently in different states, okay? But that's the rights of a private property owner. I can prohibit somebody from carrying weapons onto my property, okay? So we have that there. So the anti-Second Amendment argument that we're seeing across both the public policy sphere as well as, although to a much lesser extent, in the legal sphere, is they're saying this. All public property is where government and public gatherings happen. Therefore, firearms must be banned because we have to protect people. Again, they're relying on these interest balancing tests, which the U.S. Supreme Court has explicitly thrown out. They're also then saying that, look, New York Rifle State Pistol Association versus Bruen only protects public property. Therefore, there's no right on private property to possess firearms, and we can make it illegal unless someone actually has to opt in. So you see how that is? They're basically saying heads we win, tails you lose. That's the English definition of what they're saying. In reality, it just isn't going to pan out. And why? Well, we need not look any further than what the U.S. Supreme Court has said on the topic, because they actually have some words that pierce directly to this public-private inversion concept. The U.S. Supreme Court has distinguished between the need for self-defense in the home versus in public. And while the court has recognized that the need for self-defense is perhaps most acute in the home, however, it did not hold that the need was insignificant elsewhere or outside the home. In fact, the court observed that if the Second Amendment applied only inside the home, then half of the amendment would be nullified. And since they said that, it certainly sounds like to me that, well, we're not cutting the amendment in half, therefore it also applies outside the home. And they didn't say a third of the amendment should be nullified or a quarter of the amendment would be nullified. They said half. Half the amendment should be nullified. In other words, equal protection in and out. They choose their wording very carefully, guys. I don't think that was arbitrary or by chance. And likewise, by similar reasoning, if the Second Amendment applied only to publicly owned property, then again, half the amendment or more would be nullified. So for instance, in my state of Wisconsin, the vast majority of the land that's in our state is privately owned. In other states, I realize that those ratios may be in flux. But at the end of the day, this whole heads I win, tails you lose argument that the anti-self-defense crowd is trying to push out there, I frankly don't see it getting very far in the courts. So now to your quote of the day. The high-minded man must care more for the truth than for what people think. That's from Aristotle. Thanks, and we'll see you in the next one. Thanks for sticking around to the end of the video. If you enjoyed this one, please feel free to check out some of our other great content, and we'll see you in the next one.